This is a special report on the Hidden Killers podcast.
We're going to go back to the courtroom now for part 2 of the hearing that took place today in the case of the Petito family against the Laundrie family concerning the burn after reading letter. Let's go to the courtroom.
Case number 23-1128. We left off with plaintiff's argument. Ms. Riley, if you would like to.
I would, Your Honor, and I promise I won't take 2 hours.
Okay.
May it please the court. I think if Judge Carroll were here today, the first words out of his mouth would be, didn't I already decide these issues? Most all of the issues that have been raised here today have already been decided by Judge Carroll in a very well-reasoned decision. The plaintiffs, or the defendants in this case, are simply looking at another bite at the apple to try to argue the same issues and hoping that you, as being relatively new to the case, will overrule what Judge Carroll previously ruled. There's been no new evidence that they've submitted, no new arguments that they've made that would make any difference. And for them to suggest that Judge Carroll didn't consider some of the elements of a cause of action of intentional infliction of emotional distress when he rendered his opinion is frankly insulting to Judge Carroll. The only change that occurred in this case between the first amended complaint and the second amended complaint is that Attorney Bertolino was named as a defendant. There were some jurisdictional allegations that were included, and there was a second article that was included. But beyond that, the bulk of the complaint, the majority of the complaint, the structure of the complaint has been ruled on in a motion to dismiss before Judge Carroll, and he found that it was sufficient to move forward. This case is not based upon silence. We're not arguing that the Laundrie's refusal to provide information regarding Gabby.
I had to let my new clerk in.
Okay.
So we should be okay. She's listening in good spots.
All right.
Circuit and then also this side.
We're not arguing that the fact that they kept quiet about whether Gabby was living or wasn't and where her body was located is the subject of this cause of action. It's not. This is about the statement that was issued by Mr. Bertolino on September 14 of 2021, issued with the knowledge that Gabby Petito was deceased, issued with the knowledge, and we did suggest in the complaint at paragraph 28 that they knew where Gabby Petito's body was located. With that knowledge, and knowing that Joe Petito and Nicole Schmidt were desperately searching for any information about their daughter, they issued a statement. By the way, when that statement was issued, counsel Mr. Meltzer suggested that Mr. Bertolino was simply the attorney for the Laundries. He was more than that. He was also their spokesperson. He did all their speaking for them, whether it was related to a legal representation or not. He did all of the speaking for them. The statement that was issued on September 14, there's 3 paragraphs. The first paragraph says it's a difficult time for the families. It's a meaningless paragraph in terms of this litigation. The third paragraph says there will be no more statements issued, or that Laundries won't speak. Nothing to do with the crux of that statement, which is the subject of this cause of action. And that statement is, it is our, and I highlight our, understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our, and again, I emphasize our, hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. Counsel has suggested that this statement wasn't directed towards the Petito family specifically. But who else, if it wasn't directed to them, was it directed to? What was the purpose of the statement? What reason would there be to make that statement other than to express the hope to the Petito family that she would be located? Who else would they be expressing the hope to? Mr. Bertolino's suggestion that the statement was issued only on behalf of the Laundries is belied by his own language in that statement where he says our on multiple occasions. The defendants want you to take that statement and read it entirely out of context. They want you to believe that it was the sincere expression on the part of the Laundrie family and Mr. Bertolino that they hoped that she would be found. And if you looked at it in that context alone, arguably, I would agree, it is harmless. It could sound like a heartfelt expression of a true desire that they hope that Gabby Petito was located. But when taken in context and looking at all of the allegations in the complaint, it suggests that they knew when that statement was made that Gabby was deceased, that they knew where her body was located, and they knew the family was grieving. Mr. Meltz did a good job of cherry-picking portions of the complaint and taking them out of context, but let's put it in context. On July, and these are all allegations that are in the complaint, July 2nd of 2021, Gabby and Bryan embark on a Western U.S. journey in Gabby's van, paragraph 10 of the complaint. Gabby called her family almost daily, paragraph 13. There was no contact with Nicole Schmidt after August 27, 2021, no contact with Joseph Petito after August 21 of 2021. That's paragraphs 14 and 15 of the complaint. The paragraph 16 says, there's a belief that Bryan murdered Gabby on August 27 of 2021, and the cause of death was blunt force injuries to the head and neck with manual strangulation. Paragraph 16. On August 28, Brian Laundrie contacted his parents. On August 29, his parents contacted Attorney Bertolino, and a retainer was sent to Attorney Bertolino on September 2 of 2021. That's paragraph 20. September 1. Bryan returns home in Gabby's van without Gabby, paragraph 22. On September 6th of 2021 through September 7, 2021, the Laundries go on vacation with Bryan while Gabby is missing, paragraph 25. September 14, Mr. Bertolino issues a statement that I just read a moment ago. And again, as I said, paragraph 28 does indicate we believed that at the time it was issued that they knew the whereabouts of Gabby Petito's body. He also issued a statement on October 23rd of 2021 in which he said when Brian Laundrie left his home on, I believe it was the 13th of September, he was grieving. Definition of grieving is feeling sad because someone has died. On September 19 of 2021, Gabby's remains are located, and Mr. Bertolino issued another statement. The news about Gabby Petito is heartbreaking. The Laundrie family prays for Gabby and her family. Her death wasn't news to the Laundries or Mr. Bertolino. They knew she passed away. The only news to them was that Gabby had finally been found. Putting Mr. Bertolino's statement in context, as Judge Carroll noted in his opinion on the prior motion to dismiss, if the Laundries and Bertolino knew that Gabby was dead, knew the location of her body, and knew her parents were frantically looking for her, the statement was particularly callous and cruel and is sufficiently outrageous to state claims for intentional infliction of emotional distress. That hasn't changed. None of that has changed by the filing of the second amended complaint. As the court knows, the motion to dismiss must be confined to the four corners of the complaint. Have to accept as true the plaintiff's allegations and draw every reasonable inference from those allegations in favor of the plaintiff. Defendants have taken liberty in their motions, as I have indicated in my brief, by bringing facts in that are not a part of the four corners within the four corners of the complaint, and I'll discuss that. As was noted, intentional infliction of emotional distress became recognized as a cause of action by the Florida Supreme Court in 1985 in the Metropolitan Life Insurance case. And the Supreme Court adopted Restatement of Tort Second, Section 46, which sets forth the requirements necessary to prove a intentional infliction of emotional distress. They are deliberate or reckless, not intentional, deliberate or reckless infliction of mental suffering. Both counsel, I believe, stated that it has to be an intent to commit emotional distress. That's not what it says. Deliberate or reckless infliction of mental suffering, outrageous conduct. The conduct caused severe emotional distress, and the distress was severe. On the element of deliberate or reckless infliction of mental suffering, liability for outrageous conduct, this is under the restatement, liability for outrageous conduct arises when the wrongdoer desires to inflict severe emotional distress, when that's the intentional part, or when the wrongdoer knows severe emotional distress is certain or substantially certain to result from his conduct. That's 2. Or the third way is when the wrongdoer acts recklessly in deliberate disregard of the high degree of probability that emotional distress will follow. The reasonable inference from the allegations raised in the complaint is that the Laundries knew, and Mr. Bertolino knew, that Gabby was deceased. They knew the location of her body. They relayed that information to Mr. Bertolino. All the defendants knew that Joe Petito and Nicole Schmidt were desperately searching for their daughter at the time that the September 14, 2021 statement was issued. And I would submit that the allegations are sufficient to support an inference that the defendants knew that the statement was going to inflict emotional distress on the parents, or they knew or were substantially certain that it would, or at the very least they acted recklessly in deliberate disregard of a high probability that that statement would cause emotional distress to the Petito family. On the issue of outrageous conduct, I agree with what counsel had said. It's required to be so outrageous in character and so extreme in degree as to go beyond all bounds of decency. It requires an objective evaluation of the claimed misconduct to determine whether it is atrocious and utterly intolerable in a civilized community. And the burden does fall on the court. It's a question of law initially, not a question of fact. And generally, it is found where the recitation of the facts to the average member of the community would arouse his resentment against the actor and lead him to exclaim, outrageous. The restatement provides a non-exclusive list of examples of what outrageous conduct is. Comment C in particular says, the law is still in the state of development. The ultimate limits of the tort are not yet determined. The caveat is intended to leave fully open the possibility of further development of the law and recognition of other situations in which liability may be imposed. It's instructive to look at the cases that I've cited in my brief where there has been conduct that's found to be outrageous and where it's been found not to be outrageous. In the cases where it was found not to be outrageous, in Williams versus Worldwide Flight Services, a former employee claimed that managers and some of his other supervisors had called him racial names, created a false record of disciplinary actions against him in order to terminate him. They didn't allow him to work with other African Americans. They put him out in extreme heat and cold to load and unload planes, threatened him with job termination, accused of him stealing, and had him move dangerous and heavy equipment and cargo and work extra flights so that he couldn't take his breaks. The court found that while the conduct was reprehensible, objectionable, and offensive, it did not rise to the level of outrageous behavior. In LeGrand versus Emanuel, when 250 people were sitting in a church service, someone accused the minister of stealing money from the church to purchase a car. They called him Satan. They called him Macout, I think it's how it's pronounced, which is a name for the oppressive secret police from Haitian dictator Duvalier's regime. And they stated that his name means Satan. The court found that although they recognized branding a thief as being certainly unsettling, embarrassing, and or humiliating, it doesn't rise to the level of being outrageous. And finally, in Duval Hotel Management, bride and groom had reserved a room for their wedding reception. The day of the reception, the manager of the hotel told them the room wasn't available, and so they'd have to have their reception in the lobby of the hotel, where there was not enough room for the 190 people, and during the reception, there were other guests walking through the wedding party. Some of them attended the party, and some of them were walking through in swim trunks. The court said the bait and switch pulled by the hotel was not sufficiently outrageous to support a claim for intentional infliction of emotional distress. Now I'll move on to the cases where the court has found it. There was grounds for outrageous conduct and a claim for intentional infliction of emotional distress. In McAlpin versus Sokolay, a woman went to a hospital because she had a throat condition. She was disrobed, she had on a robe, and she was sitting in the x-ray room when a doctor came in unannounced and in the presence of other staff berated her for not paying another doctor's bill. He said he was going to call security and have her thrown out. She fled the room. She couldn't defend herself because of her throat condition. She fled the room, And the court found under those circumstances that there was reckless and outrageous conduct. In Nims versus Harrison, a teacher alleged that 2 of her students had written some sort of publication in which they used inappropriate, extremely offensive language about her. They threatened to kill her. They threatened to rape her and her children and her cousins. The court found on those grounds that's outrageous conduct. In Ford Motor Credit Company versus Sheehan, a collector on behalf of Ford Motor Company had been unable to find the debtor who was behind on payment for his car. The collector contacted the debtor's mother, claimed that she worked at a hospital, and that 2 of the debtor's children had been involved in a car accident, and she needed to get in touch with him, so the mother provided contact information for her son. In the interim, the son contacted the mother. The mother told the son about the phone call she'd received. He spent 7 hours contacting hospitals and police departments to find out where his children were, only to find out that it was false. The court found in that instance that that was outrageous conduct. In Dependable Life Insurance Company of Harris, the insurance company was required to make car payments to a bank if the debtor became totally disabled, which he did. He made his application. The payments were made initially, but then they stopped. The claims manager on 2 occasions contacted the debtor, called him a fraud, and attempted to frighten him from collecting under the policy. His car was ultimately repossessed. He went into bankruptcy, and he suffered emotional distress. The court found that was sufficient to make a claim for outrageous behavior and intentional infliction of emotional distress. In Liberty Mutual Insurance Company versus Stedman, the insurer, and this was mentioned by, I believe, Mr. Luca, the insured alleged that the insurance company delayed authorizing a double lung transplant, even though they'd been ordered to provide it, because they learned from the decedent's doctor that she didn't have long to live, and if they waited this out, in their mind, if they waited it out, she'd die, and they'd not have to pay the cost for the lung transplant. The court found, and I think it's instructive in this case, the appellate court found that viewed in isolation, the conduct the insured had alleged with respect to the lung transplant is not so outrageous that it qualifies as atrocious and utterly intolerable in a civilized community. That's the position the defendants are taking in this case. The statement itself may be benign, taken in isolation, but the court considered. However, paired with her specific allegation that the insurance company knew, based on testimony from the insured physicians, that she had a very limited life expectancy, and further considering that the insured was well aware that the clock was ticking, and that the additional emotional distress caused by the delay could well hasten her demise, the court found the conduct fell within the ambit of comment F of the restatement. Comment F says, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly, I have trouble with that word as well, Mr. Luca, peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge where it would not be so if he did not know. That is our allegation in this case. The statement's benign. Put it in context. Look at what they knew at the time the statement was made. That's what makes it outrageous. In Williams versus Mineola, another case that was cited to by Mr. Luca, there was a drug overdose. The police officers took pictures of the decedent, went to a party, and then circulated and made jokes about it. In determining whether and I will point out, by the way, in that case, the conduct was not directed at the party who was filing the lawsuit. This was something that was done at a party and was discovered later on. In determining whether the conduct of the officers was outrageous, the court stated, as for what is outrageous or reckless or what is not, we emphasize that our society, as reflected, for example, in decisions of the courts of Florida, show a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one, and the special deference paid by courts to family feelings where rights involving dead bodies are concerned is central to our decision. This area is unique, and once it is entered, behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. One obvious reason is that the bereaved are already suffering physical trauma because of the loss of a loved one and are especially sensitized to any disrespect or indignity directed at the deceased body or a representation of it. The potential for a severe emotional distress is enormously increased in that situation. All of this is well known to the ordinary person, and so a level of carelessness or callousness, which might not be considered tortious in other situations, can show outrageousness and recklessness when a dead body or a picture of a dead body is involved. Finally, in the case of Thomas versus Hospital Board of Directors, the decedent died during hip surgery in a hospital, and the death resulted from the physician giving an overdose of a particular medication which caused cardiac arrest. The doctor and the staff inside the surgical suite decided that they were just going to simply say that she died or as a result of the stress from the surgery. And that was, their report was issued, and an autopsy was not completed on the body for that reason. A week later, daughter of the decedent was burying her mother, and she, while doing so, received a phone call from the coroner saying she needed to immediately return the body back to the hospital so that a proper autopsy could be performed because he had learned of the real cause of death. The court found the decedent's daughter had sufficiently pled the elements of a cause of action for intentional of emotional distress and said, as noted in Stedman, when an actor has knowledge that the other person is peculiarly susceptible to emotional distress, the actor's conduct may become heartless, flagrant, and outrageous. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress, and therefore that the action of providing false information concerning the loved one's cause of death meets the standard for a claim of outrage. Like the last two cases, the Thomas case and the Williams case, we're dealing with a person. We're dealing with someone who was deceased. And we're dealing with parents who were incredibly vulnerable because of the fact that their daughter was missing and they didn't know where she was. And I think this falls within those types of cases where, as was noted, I think, in the Williams case, special deference is paid by courts to family feelings where the rights of dead bodies are concerned. Comment F, which I already spoke to comment F. At the time the statements were made, according to the allegations of the complaint, which the court must accept as true and which the court must draw all reasonable inferences from, the defendants were aware of the vulnerability of Joseph Petito and of Nicole Schmidt to emotional distress because of the uncertainty of where Gabby was or if she was even alive at the time the statements were made by Mr. Bertolino. The conduct of the defendants became heartless, flagrant, and outrageous when the statements were made in the face of such knowledge, where otherwise the statements would not have been so outrageous or heartless or flagrant. At this stage, it's not the plaintiff's burden to prove the allegations of the complaint. The question is whether the allegations as pled are sufficient to make out a cause of action, and I would submit that they are. Comment E to the restatement also says, in support of the outrageousness requirement, an unequal position of the parties in a relationship where one asserts power to affect the interest of the other may supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. Again, the defendants knew that Gabby was deceased. They knew where her body was, according to the allegations of the complaint. They knew that the Petito family was desperate and upset. And had they just kept quiet, we wouldn't be here. If they had kept that knowledge to themselves, we wouldn't be here. We wouldn't be standing before you having this argument. But they didn't just keep quiet. Instead, with that unequal position in which they stood vis-a-vis the Petito family, they made that statement. of hope, and they knew, or they should have known, that that would affect Joe Petito and Nicole Schmidt and cause emotional distress. Defendants suggest somehow that looking at the full statement from September 14 of 2021 will make a difference in the court's determination of whether or not there's outrageous conduct. The first paragraph and the third paragraphs simply say it's a difficult time for both parties and the Laundries are going to keep quiet. That does not in any way soften the blow of the content of the second paragraph. I'm frankly surprised that both defendants have suggested that the term reunited is subject to interpretation. They suggest it could mean the person is not alive, and they cited to various articles in which remains were reunited with a family. But the statement doesn't say, we hope the remains of Gabby Petito are reunited with her family. It says, we hope the search for Miss Petito, not her remains or her body, is successful and that Miss Petito, not her remains and body, are reunited with her family. Frankly, I think the defendants should be embarrassed for raising such a ludicrous interpretation of their own words. And by the way, if those words are subject to various interpretations, that's left to the jury to decide what it means based on credibility determinations. We believe the allegations clearly satisfy the requirement of setting forth a factual basis for outrageous conduct. And I cited the court to the Williams case where it said if differing inferences can reasonably be derived from the facts alleged, the question of outrageousness is for a jury. I'll move on to the suggestion that Mr. Bertolino's statements are protected. I would agree, as they said, that a statement made by the defendants, although extreme and outrageous, may be privileged under certain circumstances, but there are no such circumstances in this instance. As the court pointed out, the ABA model rule of professional conduct is not binding on any, don't even know if it applies. It's a model rule. But suppose it is something that we should consider. It says an attorney may, doesn't say shall, doesn't say must, an attorney may make a statement to protect the client from adverse publicity, and in making that argument, the defendants go outside the four corners of the complaint. They suggest that Brian Laundrie and Roberta Laundrie and Christopher Laundrie received a great deal of publicity, that statements were being made about them, and that Attorney Bertolino had a right and duty to protect his clients from prejudicial effect of that publicity. Well, that's not what the ABA standard says. It doesn't say he has a right and duty. But none of this is referenced. This publicity is nowhere within the four corners of the complaint. And more importantly, looking at that statement, if that's what Mr. Bertolino's intention was at the time he issued that statement, how does a statement expressing hope that Gabby Petito was reunited with her family, how does that protect his client? If he wanted to protect his client, he should have disclosed where Gabby was. Even if he had a right under those circumstances to make that statement on behalf of his clients, it didn't give him carte blanche to cause emotional distress, nor does it give him immunity from liability for issuing the statements. It simply says he can make them. It doesn't say under all circumstances he has that right. As far as the litigation privilege, it does exist in Florida to a degree. It allows litigants and counsel to zealously advocate positions in court. Defendants suggest, again going outside the four corners of the complaint, that statements were made. At the time the statements were made, there was intense law enforcement and media investigation. I'm not sure how you find that in the complaint, but they say the only reasonable inference to be drawn is that the Laundries faced a criminal investigation and media inquiries. Well, I don't know that there is any law that says reasonable inferences must be drawn in favor of the defendant. It says in favor of the plaintiff. They state that based upon the fact that there was a potential criminal investigation, Mr. Laundrie has a litigation privilege, Mr. Bertolino has a litigation privilege to make that statement. It's not reasonable to suggest or to to infer that the Laundries were the subject of an investigation, although it would be with regard to Brian Laundrie, unless Christopher Laundrie and Roberta Laundrie committed a crime that we're unaware of. The Arco case that was cited and referenced by Attorney Luca, when it talks about the absolute privilege, says, the absolute privilege, the Florida Supreme Court has explained, is part of a trade-off. The absolute privilege was created to encourage zealous representation and the free and full discovery of facts between the parties and the court. This absolute immunity resulted from the balancing of two competing interests: the right of the individual to enjoy a reputation unimpaired by defamatory attacks versus the right of the public interest to a free and full disclosure of facts in the conduct of judicial proceedings. The question here is, what was the judicial proceeding? What proceeding was going on? What proceeding was anticipated at the time that he made these statements? We don't know. There isn't one. And the statement has to be made in context of those proceedings, and that's the Ball versus D. Lights Enterprises, which I cited in my response. This, if they're suggesting the statement was made in reference to this particular litigation, it wasn't even contemplated at that point in time. Absolute immunity does not apply or include publication of a defamatory matter. This is the Ball to Lights case. Does not apply to or include publication of defamatory matter before the commencement, or after the termination of the judicial proceeding, unless such publication is an act incidental to the proper initiation thereof, or given legal effect thereto. Nor does it apply to include any publication of defamatory matter to any person other than those to whom, or in any place other than which, such publication is required or authorized by law to be made for the proper conduct of judicial proceedings. Again, what judicial proceedings were undergoing at that point in time? The statements must be made, according to the Arco Plumbing case, which I cited in my motion, the statements must be made to the court, to parties, to law enforcement, or witnesses. Arco Plumbing, that's the Arco Plumbing case. In this instance, the statement was made to the press, directed to Joseph Petito, Nicole Schmidt, and the entire Petito family. That's admitted by Mr. Bertolino in his motion to dismiss. In Buckley versus Fitzsimmons, which I also cited in my response, the court held statements at a press conference do not have any functional tie to a judicial proceeding. They also suggest they might have a qualified privilege, but that's only available when statements are made to police during a criminal investigation, and that was set forth in the Delmonico case. Mr. Bertolino cites to the Orange Lace Country Club case, but the court stated that statements necessarily preliminary to judicial proceedings include pre-suit communications required by statute or by contract as a condition to suit. There is no contractual or statutory obligation which would apply here. The defendants have suggested that there's an issue with causation, and they suggest that perhaps there's no discussion of causation in the complaint, but paragraph 40 of the complaint clearly says the emotional distress was caused by the statements made by Mr. Bertolino. They also suggest that the statements must be the sole cause of the emotional distress, and they cited the court to the standard jury instruction in civil cases 410.6, but they only told you about subsection A, not subsection B, which says, defines a concurring cause. And this is in the instruction for intentional infliction of emotional distress. In order to be regarded as a legal cause of severe emotional distress, extreme and outrageous conduct need not be the only cause. It may be a cause even though it operates in combination with the act of another, if the extreme and outrageous conduct contributes substantially to producing such emotional distress. That's what we have in this case. In this instance, we have a family undergoing distress, wanting to know where their daughter was. She hasn't contacted them in a long time. And along comes this statement made by Mr. Bertolino, and the statement we would submit is a concurring cause of the emotional distress. Restatement, comment J to the restatement says, severe distress must be proved, but in many cases the extreme and outrageous character of the defendant's conduct is in itself important evidence that the distress existed. The allegations of the complaint show the conduct itself the nature of the conduct itself fits within comment J because it's so extreme and outrageous. Knowing someone has passed away, knowing a family is grieving to express false hope that she may still be alive is outrageous. Attorney Luca also discussed the issue of agency. It's an interesting argument in which the Laundries seek to distance themselves from Mr. Bertolino by suggesting that because the complaint alleges malice, he was acting alone and not on behalf of the Laundries. But as Judge Carroll noted in his opinion, an attorney's acts are the acts of the principal, the client. And that's the Stinson versus Pravat case, where the court said the principal is liable if the wrongful act is done while the agent is acting within the scope of his apparent authority, even though the act was not authorized by or was forbidden by the employer, or was not necessary or appropriate to serve the interest of the employer, unless the act was done to accomplish his own purposes as distinct from the employer's business. That sounds more like an affirmative defense to be raised or an argument to be made at a later time that he wasn't acting on behalf, that Mr. Bertolino was not acting on behalf of the Laundries when he made that statement. But within the four corners of the complaint, there's nothing to support that argument. In fact, the statements themselves issued by Mr. Bertolino say we and our. In sum, I would submit to the court, well, I do want to address two other issues that were raised. I apologize. I believe I've addressed them. In sum, I would submit that just as Judge Carroll found, the allegations of the Second Amendment complaint are sufficient to set forth a cause of action for intentional infliction of emotional distress, and both motions to dismiss filed by the defendants should be denied. Thank you.
Ms. Riley, I do have a question for you. If you look at, for paragraph 40
of the complaint,
of the complaint, paragraph 40, subsection A and B, you began your argument indicating that this is not a silence case. This is about statements made.
And Judge, I'll agree to strike those two paragraphs. They shouldn't be there. I agree.
Okay.
We're not. This cause of action is not based upon their silence.
So then you will strike A and B, C, D. Yes. I'm not going to take out the factual allegations earlier where that was said, because in my view that shows a course of conduct. That shows the context. But right. but I do recognize Mr. Metz's point in that because we don't have specific to each of these counts, we don't have a specific title for the count. It would the complaint is intended on making sure that we understand which statements we're actually talking about. And I also recognize in your complaint in paragraph 33 where it says, with regard to Mr. Bertolino, he released numerous other statements regarding Christopher Laundrie, Roberta Laundrie, and or Brian Laundrie to the national press and to the Florida and into Florida in particular, while Mr. Metz kind of breezed by that as far as a jurisdictional statement. Are these statements that you're also indicating could have caused?
No, that was purely for jurisdictional
Okay,
reasons.
so therefore the statements that we are talking about here are specifically the statement of hope that was done at that we've talked about ad nauseum here.
Yes.
And then the prayers statement.
Yes.
And then that's it.
Yes.
Okay. All right. Thank you.
Thank you.
I am assuming you all know that I'm going to reserve on this particular issue before ruling. So that is what I'm going to do on the motions to dismiss. And I hope to have orders out for you all shortly with regard to those. We do have 2 other issues that we need to address.
Judge, I maybe had a rebuttal I could do in 1 minute. Could I just
1 minute?
Yes.
Yes, you can give me a rebuttal.
Timing you.
Go for it.
It's like the trial attorney that comes up for cross-examination says, I have one more question.
Judge, I gave a closing once in 22 minutes for a 4.5-week trial, so I'm going to do this.
Okay.
Paragraph 40 doesn't talk about causation. So Mr. Riley said it did. It doesn't, and causation is missing throughout. Mr. Riley talked about recklessness. Count 3 and count 6 does not raise recklessness. It raises willfulness and maliciousness. There are 4 elements to intentional infliction of emotional distress. At best, Judge Carroll partially commented on one of them. You take those 4 elements as a checklist, and you read through this complaint, and you read through all of the counts, you're not going to check all 4 off. It doesn't set forth a cause of action for intentional infliction of emotional distress. It doesn't have all the elements. And that's within the 4 corners. And for this type of claim in particular, your role and what the courts have said are your responsibilities in the scope of what you can rule on clearly puts you as the gatekeeper for this. And there's not sufficient evidence for it to move beyond this point. Thank you.
Okay.
That was 1 minute and 20 seconds.
I had a comment.
Mr. Luca, did you have anything else you wanted to add?
Your Honor,
Very
I'm sure everybody would appreciate it if I didn't speak again, but I would just ask the court to consider. I know Mr. Metz mentioned that counts 3 and 6 had the willfulness, maliciousness language as opposed to deliberate and reckless. It's the same for all the counts against all of the defendants. So to the extent that you're considering that argument, that applies. It wasn't just for the counts that applied to his client.
Okay, gotcha. All right, so I'm going to be reserving on that ruling. The rebuttal has not made me change my mind on that. I'm going to be reserving, and we've got our next issue. What would y'all like to handle next, gentlemen?
We could do the easy one, which is the third request for production of documents where I asked for any account statements which showed transactions in excess of $10,000.
Yes.
Mr. Lupa has indicated that all those transactions were for payment to Mr. Bertolino, and that he was satisfied to have the court take a look at it and determine if he's correct, and I'm fine with that as well. If the court looks at it and says there's no withdrawals or transfers in excess of $10,000 that went to anyone, that didn't go to anyone other than Mr. Bertolino, then that satisfies my inquiry in that area.
Okay, and I looked at that earlier today.
What's the date? We want to know the date. And Judge, these motions don't involve me. Would you mind if I stepped out briefly and came
Sure,
back?
absolutely.
Thank you.
Good.
I've got copies of the records if you wanted to
Okay,
take a look at
because
them.
you gave me, I know
did.
that I have the,
I got them here if it's easier for me
Chasing.
just to hand them to you.
okay. I've got it right here in front of
Okay.
me, unless it's different.
You know, Your Honor, I don't know if we included this one because I don't know if I had it at the time. This
Okay.
sort of explains, this is just a check, it sort of explains like one of the entries.
Oh, okay.
So, Your Honor, so if we look at these records, first of all, when we're talking about transfers, I know Mr. Riley said that he wasn't interested in payments to Mr. Bertolino. There is a payment that's from Mr. Bertolino too. So let me, if I could just explain the records to you, this might go a little more quickly.
Okay.
So if you look on, so one page of the bank statement is for a checking account and one page is for a savings account. Mm-hmm. So if you look on September 1st, there's a fairly large deposit. And that deposit corresponds from that check from the law firm. That's a law firm that's associated with Mr. Bertolino. So that's what that check is. Then that amount of money is transferred from the savings account to the checking account. And then about a week later, there's a check that's written to Mr. Bertolino. So
For far less.
for far less, yes. And then, but then the remainder of the money just stays in the checking account. And so, Your Honor, that the payment that came in, the deposit, was for like a business transaction, totally unrelated to anything in this case. And you'll see that the check that was deposited is actually dated August 13th. So it would be outside of Mr. Riley's third request for production, outside that date range. It also would have predated anything that would have happened between Brian and Gabby.
And so I'm not interested in that. I know what that is, and I'm not interested.
Okay, so then the only other transaction would be the payment, the check to Mr. Bertolino about a week after that.
Okay. If you just give me 1 second, because I want to specifically look at the production request, and then I can affirmatively tell Mr. Riley that you have given him everything he needs or not.
So I haven't given him these records because again they don't meet with.
I know, but what if I'm going to look at his request, specifically look at his request, look at what you've given me, and then tell him he doesn't have to give them to you, or he does.
Okay.
Okay. And it's request number.
It's the third request for production. I believe it's the only request within that production.
Okay. August 26, 2021 through September 14th. Based on these records, your none of this would comply with your request.
Okay. I'm satisfied.
Thank you.
Thank you.
So then, as far as the motion to compel, based on my in-camera review, I'm going to be denying the motion to compel. And Mr. Letby, you could prepare the order for that?
Yes, thank you, Your Honor.
Wonderful. And Mr. Letby, just to make sure that it doesn't end up out in the world, I'm going to give you this back.
Okay, thank you, Your Honor.
I'm giving you back your entire tab 5 for that.
Thank you.
All right, and we have one additional motion that we have to take care of.
Yes, Your Honor. The only remaining motion is the motion for protective order. And this relates to the letter that was authored by Brian Laundrie, which we discussed, I believe, at our last case management conference.
Yes, sir.
So this is just the motion that now brings it before the court.
Okay. And if you would like to, it's your motion for protective order, so if you'd like to get us started.
Thank you, Your Honor. Your Honor, we filed an affidavit of Mrs. Laundrie explaining her authoring the letter and the purpose of the letter. Her affidavit explains that she wrote the letter to Bryan and never intended for anyone else to see it. She wrote it prior to Bryan and Gabby leaving for their trip, so it does not relate to any of the events that occurred thereafter. Her choice of words, in hindsight, are unfortunate, but that doesn't mean that the letter is relevant. Plaintiffs argue that Mrs. Laundrie's affidavit is a self-serving statement of a party, so the court should disregard it. Of course, the plaintiffs don't offer anything that contradicts Mrs. Laundrie's affidavit other than that argument. This was a private note between a mother and a son. They would have been the only people to know the circumstances regarding its creation. Mrs. Laundrie is the only person who can comment on it at this point. Now, the letter is undated, although she wrote the letter because she and Bryan were experiencing a difficult period in their relationship, and he was about to leave home. He was about to go on this long trip with Gabby. And she was hoping to repair their relationship before he left. Now, there are several contextual clues within the letter demonstrating that it was written before Bryan's trip. And, Your Honor, I did provide you with a copy of the letter, I believe. So first, Your Honor, the letter doesn't mention Gabby at all.
Judge, how can I respond to this if I don't see the letter?
It is.
Well, first of all, Your Honor, I would note that Mr. Riley has seen the letter.
I don't. That was well over a year ago, and I don't have.
He has a point.
Okay, so I understand.
With the contextual clues, it's hard to give context. I mean, with the last motion that we had, that's an easy thing for me to look at, and hopefully Mr. Riley to trust that I can read a bank statement and say, hey, there's none of these things that you're asking for in it. But this is, you're asking me to make an interpretation, and that I think due process would permit him to be able to argue that.
Understood, Your Honor. Understood. So let me just bypass then referencing any of the content of the letter.
All right.
So going back, Your Honor, we have provided this affidavit from Mrs. Laundrie that explains the context in which she wrote the letter. And the plaintiffs certainly don't offer any evidence or any contrary affidavits that Mrs. Laundrie's affidavit is incorrect, or any other information regarding why the letter was authored, when it was authored, any of those details. They simply call it a self-serving attempt to withhold a key piece of evidence. And this leads me to my next point, Your Honor. This letter is not a key piece of evidence. It was a private note between a mother and son. The plaintiffs never saw it. The letter has not caused them any emotional distress. And more specifically, the plaintiffs haven't demonstrated that the letter had any connection to Mr. Bertolino's statement, which is the foundation of their entire claim. Now, the plaintiffs cite to HEPCO Data, LLC versus HEPCO Medical, 301 Southern 2nd, 406. It's a Florida 2nd DCA case from 2020. And also to Dees versus Kidney Group and Kijker versus Lopez. Those sites, again, are in their motion. For the argument that irrelevancy is not a proper ground for protective relief under Rule 1.280 Section C. Now, Your Honor, I believe that misreads the point that those cases were making, which is that for a protective order, there has to be something in addition to relevance as an objection. There must also be a showing of annoyance, embarrassment, oppression, undue burden, or expense. In other words, relevance is not enough. For example, the Dees case that the plaintiff cite said, the protective order prevents any discovery concerning two prior clients and a new venture formed by the other two members of the company. The information appears relevant to Dees' claim or reasonably calculated to lead to the discovery of admissible evidence. Again, so the Dees court considered relevancy. It was just that you needed to go that extra step about showing embarrassment or oppression, undue burden, or expense. And Your Honor, we've cited to a number of cases in our brief, which we provided to you, where courts precluded discovery on matters that were irrelevant or not reasonably calculated to lead to the discovery of admissible evidence. Just to give one example, in Hoogland versus Dollar Land Corp., 330 Southern 2nd, 509, 4th DCA, 1976, the court held, the appellant Hoogland was entitled to a protective order as to most of the material sought until such time as it may appear that discovery of those documents is relevant or that may reasonably lead to relevant evidence. So while not the only factor, relevance is a significant part of the court's consideration. The plaintiffs still have to comply with Rule 1.280B, which only permits discovery regarding matters that are relevant or reasonably calculated to lead to the discovery of admissible evidence.
Why do you believe that this letter would, you've seen it, now I've seen it, why do you believe that this would not be relevant?
Well, Your Honor, as Mrs. Laundrie's affidavit states, it was written...
Aside from statements made by your client, which arguably have a credibility factor that has to be addressed by a fact finder, what would be the reason that this would not be relevant?
Well, Your Honor, if I can't use the affidavit and I can't use the actual words of the letter, to describe why it wouldn't be relevant, I'm not frankly sure what to say, because those are the two, the actual content of the letter and Mrs. Laundrie's affidavit are the reason why it's irrelevant, because she says she wrote it before Gabby and Bryan went on their trip.
Okay.
My argument regarding the context of the letter was going to be that shows that it was written before they went on their trip.
Because this sounds like an argument that you make at trial when everybody has seen what you're trying to present, and then at that point in time we dire the witness, we make some credibility determinations, and then we decide whether or not it's relevant or not relevant. Rather than at protective order discovery stage where we're bringing in Mr. Riley here with his hands tied behind his back, not knowing how to argue it. I mean, essentially, when I took away the affidavit and the words of the letter away from you, I essentially put you in the exact same position that Mr. Riley is now in.
I understand, Your Honor. I mean, but certainly, he has the affidavit. He has the ability to develop additional evidence through the course of discovery, take Mrs. Laundrie's deposition, stuff like that, where perhaps he could develop.
Ask her about a letter that he doesn't know.
I'm not suggesting that. I'm just saying that the only facts that we have at this point are the facts that we have.
I understand. We're very early.
Right. And Your Honor, the reason why, this letter is particularly sensitive is even the plaintiffs acknowledge in paragraph 20 of their response that it is understandable that the Laundries would argue that the letter is embarrassing and most prejudicial to Roberta Laundrie. And our concern in this case is...
To be fair, that is not an argument for discovery, not being required to turn over something in discovery. That is an argument for a motion in limine.
Well, no, Your Honor, it is an argument for discovery because under the standard for the protective order, if something is embarrassing, it can be protected. Okay? So in this situation, what we have is something that is embarrassing, and given the media attention on this case and how this letter could, would be put out into the public potentially, it's on fire.
Are there and please correct me if I'm wrong on this or lead me in the right direction on it, but there is case law that suggests that the protective order does not necessarily prevent the other side from getting the discovery, but rather prevents the dissemination.
Well,
I mean, is there a middle ground here, rather than plaintiffs do whatever they want to with it, and you saying it never gets to see the light of day? Is there a middle ground here where we can proceed and actually give them some meaningful attempt to utilize it and determine whether or not it would be a relevant exhibit at trial?
There certainly could be, Your Honor. I mean, we could, if we wanted to, we could work something out where we do enter into a protective order whereby Mr. Riley could see the letter and then.
Because that's not my understanding of what you're asking for in your protective order.
Right, that's right. I'm asking.
Order is like I want it to be shredded and gone and forever and ever.
Right. I am asking for a Rule 1.280C protective order, meaning we don't have to disclose it, as opposed to a protective order where Mr. Riley and I agree to some terms as to the protection of it, like how it can be used, who can see it, things like that.
Okay.
Now that's something we could certainly work on. Although, Your Honor, I mean, I think I would be remiss without saying that regardless of, if you totally disregard Mrs. Laundrie's affidavit, totally disregard.
I'm not saying that I am.
No, I understand.
I'm asking you the question so that I can see the full crux of your argument.
I understand. There is still a requirement that discovery is limited to those matters that are relevant to the litigation as framed by the parties' pleas. Okay? And so in this situation, the plaintiffs don't dispute that they've never seen the letter. They don't dispute that Mr. Bertolino's, other than maybe in his association with this case has seen the letter, but that he saw the letter at the time he issued his statement, or that it had any influence on his statement, or anything like that.
They have alleged, however, that the defendants knew that Ms. Petito had passed and knew of the location in which her remains lay, and that factual allegation is one that they will have to prove in order to be successful at trial, because without knowledge, then so while this statement may not have been the one to have caused the intentional infliction of emotional distress, it is the ramp up to that. It's the elements that it potentially could allow the elements of that to be proven. Does that make sense?
No, it does make sense, Your Honor. I can understand that perhaps, but again, I can't reference the contents of the letter, so I'm just I'm struggling a little bit to try to make sure that those words don't come out of my mouth.
Paige, I don't know if this would be helpful, but so it sounds like what we're really talking about is whether a confidentiality order should be in place. And in all fairness, I think we've probably asked certain things from the plaintiffs in terms of written discovery where that may not be a bad idea. But of course, if you sort of start the discovery process without one, it's harder to get back in.
I agree.
So perhaps whatever ruling the court makes, we at least would have some grace period to consider putting a confidentiality order in place, because that might help alleviate everyone's concerns for other issues moving forward as well.
That is an idea to consider. I want to hear, Mr. Luke, I have interrupted you a lot. But
no, that's fine, Your Honor.
You are helping me out, so I appreciate that. I appreciate the indulgence.
Yes, of course.
Even though if it's annoying, I'm sorry. Mr. Riley, would you like to?
Yes, Your Honor. As the court well knows, we're not suggesting that the letter caused emotional distress to my clients. We're suggesting the letter, if determined to have been written after Gabby passed away, is proof that they were aware that Gabby passed away at the time that the statement was made on September 12th. That's the importance of the letter. As we all know, the letter references burying a body, bringing a shovel and burying a body, baking a cake and putting a shiv in it. Those are criminal acts, by the way, that Roberta Laundrie has said she would commit. But those words are in that letter.
I don't think shiv's in the letter, but.
Or then a saw or something, baking something in a cake. And by the way, her reference in her affidavit to these children's books that as try to explain why she wrote that letter to her son is ludicrous, because there's nothing about burying a body or bringing a shovel or putting something in a cake if somebody goes to prison, although Mama Bear did say she would bake Little Bear a cake on his birthday. This whole argument is based upon the affidavit of Mrs. Laundrie. Mrs. Laundrie is a party. Mrs. Laundrie has bias and prejudice and a reason to say the things that she did in her affidavit. And if I were in her shoes and I had written that letter, I'd probably say the same things. but that subjects her to a credibility determination, and the court can't determine her credibility based upon that letter, and credibility is for the jury to determine. The cases that I cited regarding relevancy, are all second. Two of them are second DCA cases. One is a fifth DCA. None of the cases that Mr. Lucas cited in support of his position with regard to relevancy are second DCA opinions. And also, it's their burden at this point to show good cause to protect them from annoyance, embarrassment, oppression, or undue burden or expense that justice requires. Well, I haven't heard from them what justice requires under this circumstance that would entitle them to a protective order. But the basis of their argument is relevancy. And again, Mrs. Laundrie has admitted she wrote the letter. The counsel's admitted that the letter is undated. It's up for a jury to determine, or up to a jury to determine when the letter was written. But I cited the court to the HEPCO case, which says relevancy is not a proper ground for protective relief under Rule 1.280C, and that's 301 Southern 3rd 406. It's a 2020 second DCA opinion. I cited the court to Dees versus Kidney Group, a 2009 second DCA case, which says it upheld the circuit court's finding that the information sought to be protected is not related to any pending claim, and the fact that it is not reasonably calculated to lead to the discovery of admissible evidence is not sufficient to issue a protective order. And I also cited the case of Kiker versus Lopez, a fifth DCA case from 1998, which held that holding that the argument that information is not relevant to the issues in the lawsuit does not satisfy the moving party's burden to show that producing the requested information would subject him to annoyance, embarrassment, oppression, or undue burden or expense. The simple fact that it might cause her embarrassment is in and of itself not sufficient to issue a protective order in this particular case. We're not talking about compromising pictures. We're not talking about financial information. We're talking about something penned in the handwriting of a party to this particular case. The cases, none of the cases that were cited by Mr. Lucas support the suggestion that a protective order can be issued based upon the affidavit of a party. Not one of them. That basically what they're asking you to do is to make a credibility determination at this point, which will preclude me from moving forward with a certain piece of evidence, a critical piece of evidence in this particular case, to show what information the Laundries had at the time that Mr. Bertolino made the statement. So I don't see any grounds upon which they're entitled to a protective order in this instance.
Say I agree with you, Mr. Riley. What argument would you have against a confidentiality?
Why? I have no reason to. I have no reason to agree to a confidentiality agreement. I mean, that hampers me. Why would I agree to a confidentiality? So then, if I'm asking her about it in a deposition, so now the deposition transcript is going to be confidential as well, or a portion of it. I mean, I don't see a reason why I need to be hamstrung. We're not talking about financial information, which would be the appropriate subject of a confidentiality agreement. We're not talking about trade secrets. We're not talking about something that, if is disclosed, is going to give some party an advantage, an outside party an advantage in moving forward, such as if trade secrets were disclosed. That's not what we're talking about. We're talking about a letter in the handwriting of a party.
Mr. Lucas, do you have something to add to that?
Your Honor, I think at this point we probably wouldn't be in favor of a confidentiality agreement on this issue either, just because Mr. Riley just put probably the two worst parts of the letter on the record in open court. So, I mean, and that's what we would be dealing with that throughout the litigation. I mean, he can. Okay,
so y'all don't want to. You just want me to rule then?
I think we just want you to rule.
Okay, very good. Well, that made that decision easy. I don't have to. have reviewed defendant's motion for protective order and all applicable responses, as well as heard all of the argument given here today, and both attorneys. I appreciate both of you answering my questions. I really do. And at this time, I am going to be denying defendant's motion for the protective order. Are there any other objections with regard to this particular piece of discovery that are currently pending?
No, Your Honor. No, Your Honor.
Mr. Luca, is there any reason why I would not be able to give Mr. Riley the letter today? Or if you all have an extra copy, anything precluding me from doing that?
The only thing I would want to do would maybe put a bait stamp on it.
Absolutely, that sounds.
But other than that, I mean, I suppose you can just give him that copy, and I can bait stamp it, provide him with that like at a later time, just so he can keep a record of like where that document
sounds good.
falls within the range.
Yes.
Does that work for you, sir?
It does.
Okay, and would you do the proposed order?
I will.
Okay, very good. Let's see. Oh, wonderful. Okay, I don't mind giving him this one. I just need to. I was going to stamp it and sign it as the one that was shown. All right.
Is this the best copy there is?
No, I think.
No, probably not.
Okay.
Do you want to trade out just so that I have the full?
Sure, that would be great. Yeah. May I approach, Your Honor?
Yes. Mr. Riley, do you have any issue with me putting my initial at the bottom here as the ones that was reviewed in court?
I do not.
Okay. Gentlemen, is there anything else that I need to take care of today?
No, Your Honor.
No, I don't think
All
you.
right.
Thank you.
Thank you. It has been an absolute pleasure to work with all of you today, and we will see each other soon, I believe. And I will have an order for the motions to dismiss out shortly.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
This is breaking news on the Hidden Killers podcast.
Keep it here. We'll keep you up to date on this case and the information surrounding that letter as it continues to develop. I'm Tony Bruschi. Stay with us.